What follows is an explanation of drugs and alcohol regulations related to commercial truck drivers. Generally, all CDL drivers who operate commercial motor vehicles subject to the CDL requirements on public roads in the U.S. are performing safety-sensitive functions and are subject to DOT drug and alcohol testing in 49 CFR 382.103. This includes all full-time, part-time, intermittent, backup, and international drivers. DOT drug tests require laboratory testing for the following 5 classes of drugs: marijuana, cocaine, opiates, amphetamines and methamphetamines, PCP. DOT drug and alcohol tests include a pre-employment drug screen, which must be negative before a commercial driver is permitted to operate a commercial motor vehicle. Drug and alcohol tests of the commercial driver must be performed after any accident or collision that results in a fatality. Any collision resulting in disabling damage to any motor vehicle if the commercial driver received a citation from law enforcement, and any collision resulting in immediate medical treatment away from the scene if the commercial driver received a citation from law enforcement. CDL drivers are subject to random drug tests throughout the year. Drivers who appear to be under the influence of drugs or alcohol can be immediately tested. Employers are required to train their CDL driver supervisors to detect the symptoms of driver impairment. A commercial driver is required to be retested upon completion of the return to work process whenever the driver either tested positive for drugs or alcohol, refused to be tested, or who otherwise violated the prohibitions of the regulations. The return to duty process must be completed with a DOT qualified substance abuse professional. This test is directly observed, and a negative result is required before resuming driving duties. After return to duty status is approved, the driver must also submit to follow-up drug testing. This testing is to be prescribed by the substance abuse professional for a minimum of 6 directly observed tests in 12 months. But that can be extended an additional 4 years. A commercial driver has failed a drug or alcohol test by testing positive to a drug test, or registering a 0.04 or greater alcohol content. Either of these results requires immediate removal from any safety-sensitive functions, such as driving, until successful completion of the return to duty process with a DOT qualified substance abuse professional. A commercial driver's refusal to submit to a drug or alcohol test is generally equivalent to testing positive to a drug or alcohol test. The driver is required to immediately be removed from performing safety-sensitive functions, such as driving, until successful completion of the return to duty process with a DOT qualified substance abuse professional. The DOT regulations outline what counts as a refusal to test for drugs and alcohol. Some refusals are determined by medical review officers and alcohol technicians. For others, the determination is the employer's responsibility. The Gerard's law firm represents families who have had a loved one injured or killed by a trucking collision. Call us at 214-346-9529 for a free consultation.